Bob Moses is a national treasure, and no one can deny it. He's recipient of the MacArthur Genius Award. His impact on American culture is immeasurable. His presence in our portion of the American narrative is profound. Bob Moses.
So I don't have a lecture. I'm not going to read something. I'm not going to read a lecture. Right? I am going to read some documents that kind of set a tone for what I'd like to talk about. I'm going to ask you to think about our country in terms of its constitutional eras, and ask you to think about, well, what story do you carry in your head about our country? And so I've been trying really hard to get a story in my own head about our country. And so I've come up with a story which looks at the country in terms of 3 constitutional eras. From 1787, roughly down to the 1860s, and then from 1875 down to the 1950s or 60s, and then now we are in, I think, our 3rd constitutional era. I was struck by what Beverly said about it was 1855 here when they integrated schools, because part of my story about our country is that we lurch, right? And I think that's a really poignant example, right? That we, as a country, we lurch forward and backwards. But in my story, we lurch forward and backwards roughly in units of time that are roughly 3/4 of a century. So we're celebrating 50th, 50th anniversaries of various markers that happened in the 60s. So 50 is 2/3 of 75. I think we're lurching backwards, but I think we're lurching, right? And we're going to lurch. The question for the younger generation is, are you getting yourselves ready for another lurch, right? If we think about how our history has evolved, roughly every 3/4 of a century, we've lurched forward. So I want to pick up the story. I experienced the civil rights movement as an alliance of the bottom and the top. So we were at the bottom working with the sharecroppers, domestic workers in Mississippi. And at the top was a very small sliver of American government, the Civil Rights Division of the Justice Department. And the person that I encountered most often in the field was John Doerr. John passed away just this past winter. He was, I think, approaching 94. And what I want to read is a couple of pages of his memorial for Burke Marshall. So the lineup in the 1960s, Kennedy was still president. Bobby Kennedy was our Attorney General. Burke Marshall was the Assistant Attorney General for Civil Rights. And John Doerr was his chief litigator in the field. So John is speaking at Burke's memorial. He said, Burke led the division until 1965. During that time, he guided the country from a segregated second-class system for black citizens throughout the Solid South to the events at Selma in early 1965 that brought the country the Voting Rights Act of 1965. And you know, we just celebrated the 50th anniversary of that. In May 1961, Burke advised Attorney General Robert Kennedy and President John Kennedy during the constitutional crisis of the Freedom Rides in Montgomery. Everybody remembers the Freedom Rides? Right? The Freedom Rides actually was the penetration of the sit-in movement into Mississippi. Right? Burke quickly came to understand better than anyone the complex legal and procedural problems caused when a state threatens to abandon its public safety responsibilities whenever black citizens attempt to exercise their constitutional rights. So there's this setup between the feds and the people and the states, right? And that has kind of played itself out over the evolution of our country. During May, Burke recommended to the Attorney General that the department file 4 voter discrimination suits in Mississippi, one of them against Walthall County, a backcountry county lying along the Mississippi-Louisiana border where there were no black citizens registered to vote. In early July 1961, Bob Moses, a field secretary for the Student Nonviolent Coordinating Committee, SNCC, wrote a letter to Burke Marshall saying that his organization intended to operate in Mississippi, encouraging black citizens to register to vote. On July 13th, the Attorney General sent Burke a handwritten note, which read, "What do you intend to do about Mississippi?" On Thursday, September 7th, John Hardy, a field secretary for SNCC, those are my grandchildren that just came in. We hope they're gonna So Hardy was working for SNCC. We had recruited him, and he brought 2 elderly black residents to the courthouse in Tylertown. So one of them told John Wood, the registrar, that she had come to register to vote. Wood told her, "I'm not registering anyone now." Hardy stepped forward and told Wood his name. Wood told Hardy he wanted to see him. Wood went to a desk and pulled out a gun. This is the registrar, pointed it at Hardy and told him to get out. As Hardy was leaving, Wood hit him on the head with the gun. Hardy, bleeding, stumbled outside and tried to find a law enforcement officer. Hardy met the sheriff in the street, but when he tried to make a complaint, the sheriff arrested him for disturbing the peace and put him in jail. When Burke learned what had happened, he immediately sent 2 division lawyers to investigate. They were gone a week and returned on September 16th with statements of what had happened at the courthouse. They could not believe how bad the conditions were for black citizens along the Mississippi-Louisiana border. One of the lawyers made it clear that fear among the black citizens and the intimidation and corruption among officials in Mississippi was so widespread that he believed it would take a commitment of enormous resources by the federal government even to scratch the surface in Mississippi. He questioned the willingness of the Kennedy administration to commit such resources. The following Monday, I called a meeting. This is John Doerr now talking. I called a meeting of the division lawyers. As we reviewed what we had learned, Burke came in. He listened and was told that Hardy's trial for disturbing the peace was to occur the following Friday. In spite of the well-established rule that federal courts do not enjoin state criminal prosecutions, Burke immediately authorized the division to seek to enjoin the case against Hardy. With that action, Burke gained the respect and admiration of every lawyer employed in the division, and from that day on, the division lawyers went all out in enforcing the existing laws ensuring the right to vote. So what happened was John came to Federal District Judge Cox in his chambers to argue that the judge should enjoin the state. John Hardy was there, and I was there with him. John was due to appear in Tylertown, the county seat of Walthall, the next morning at 9 o'clock. And so, of course, Cox did not give Doa what he asked for. And after it was over, Doa came up to us and said he would have to call Burke and find out what he needed to do, if anything, next. Right? So he says here, we filed a complaint on Wednesday. On Thursday, Judge Harold Cox refused to stay the criminal case. Burke directed us to file a notice of appeal and to go to Judge Richard Reeves of the United States Court of Appeals for the Fifth Circuit in Montgomery. So John said, Burke has said that we should fly to Montgomery. He asked, they called Judge Reeves, and Judge Reeves asked him if he would bring the Mississippi State Attorney General with him. So he chartered a plane that night. They got to Montgomery about midnight that night, woke up Judge Reeves, and got a stay. So in the meantime, John and I left Jackson and went down to Macomb to stay with C.C. Bryan, who was the head of the NACP in Macomb, because John had to appear in court at Tylertown the next morning. We got to court early, before anybody else got there, so nobody knew we were there, because you go up in the court and you sit on a little shelf in the back of the court that has no seats on it, just a little shelf for black people to sit on, and you could see over, right? And so the court filled up with white men, and then finally the county prosecuting attorney came in and announced that a stay had been obtained and the case was postponed. And so John and I hit it down the stairs, and they came after us like bees, right? Coming out, they saw us as we came out of the courthouse and made our little escape. So what was going on? So what was going on in Southwest Mississippi in 1961 was a battle between the feds and the state and SNCC, right? And at issue was whether or not the feds would actually enter into this voting where there was threat of violence, right? I had been beaten, John had been pistol whipped, Herbert Lee had been murdered, right? Herbert Lee was one of the people that we worked with in Amite County, right? So in the end, Burke Marshall decided that the federal government couldn't risk bringing cases in those areas where it might be forced to do what it did in the Meredith case at Ole Miss, right? And actually have marshals or have a federal police force around the voting. What did happen was that SNCC kept pushing the feds around the voting issue and eventually got them to change their strategy. So instead of going county by county against individual registrars, the Justice Department filed 2 suits against 2 states, one U.S. v. Mississippi and the other US v. Louisiana. And I want to read to you something about the US v. Louisiana case, Judge Wisdom's decision. So Judge Wisdom was on the Fifth Circuit Court of Appeals, and he handed down his decision in US v. Louisiana in December 1963, about a month after Kennedy was assassinated. This is a law review talking about his decision. United States versus Louisiana was in many respects a landmark opinion. Its thorough, scholarly consideration of the history of black disenfranchisement provided a devastating indictment of the unconstitutional practices prevalent in the South. Its affirmance by the Supreme Court wiped out the understanding test, one of the most discriminatory prerequisites to voting. That affirmance also constituted the first Supreme Court endorsement of a reparative injunction, an order seeking to undo the present effects of past discrimination rather than just to prevent future repetition of prior illegal conduct. So let me say that again. Right? The idea that the order undid the present effects of past discrimination, not just preventing future repetition of prior illegal conduct. Because the class of persons benefited by a reparative injunction is not identical to the class of persons who have been directly injured by the past discriminatory acts, US v. Louisiana is a direct ancestor of affirmative action decrees. Right? So we got the enforcement provision of the Voting Rights Act in 1965 through the acts of the judges Frank Johnson in Alabama, Judge Wisdom, Judge Tuttle in the Fifth Circuit. So we got those not because we marched, right? Marching didn't get us the actual decisions by the courts that said that the state, because Wisdom said the state of Louisiana can no longer be responsible for overseeing the registration of people and black people. It has to be removed to the federal courts. Right? So when the sit-ins broke out in 1960, I was teaching school at the Horace Mann School in New York, and my uncle, my father's brother, Uncle Bill, was a professor at Hampton, and I knew that I had to go down and take a look at what was going on. The students at Hampton were demonstrating in Newport News, and Wyatt T. Walker, who was a minister at that time in Petersburg and later became the executive director of SCLC, King's organization, he came down to do the mass meeting and announced that King was going to set up an office in Harlem. And so I got all the information and made it to the organizing meeting of that Harlem office. And so Bayard Rustin was running that office. Bayard, remember, did the March on Washington with A. Philip Randolph. And so I would go down every day after school. And after they had the big fundraising, Harry Belafonte and Sidney Poitier headlined a fundraising at the 369th Armory. And my father actually worked there as one of the janitors. And after they did the fundraiser, I asked Bayard if I could go down and work with King. I thought King was still in Alabama. And Bayard sent me to Ella Baker. And Ella at that time was the director of SCLC. And it was in Ella's office that I learned about SNCC. Jane Stembridge, who was a young theological student, white, from Virginia, who had been at Union Theological Seminary in New York and went to the meeting that Ella called at Shore University that became the organizing place for SNCC, had gotten along very well with Ella, and Ella she had volunteered sort of be the first office person for SNCC. And then the SNCC coordinating committee came through. Marion Barry was the first chairperson of SNCC, and they decided they were going to hold the first Southwide meeting of SNCC in the fall of 1960. And Jane said, well, we don't have any information from Alabama, Mississippi, and Louisiana. And so she got together with Ella. Ella knew everybody who had done anything across the South. And they made up a list of people, put me on the Greyhound bus, and I went scouting for SNCC. This is the summer of 1960. When I hit Cleveland, I met Amzie Moore. Amzie was on Ella's list, and he was the head of the NACP, and he was the one who told us what we should do, that we should come into Mississippi and do voter registration, not do direct action and public accommodations. And so I had a year to go on my contract, and I told Amzie, well, I want to come back and work for SNCC on your voter registration project. He had taken me up to meet Father LeBeau, who was a black Catholic priest who had a parish in Mount Bayou, which is about 10 miles up the road from Cleveland. And he thought that we were going to be able to start our voter registration with Father LeBeau. But in the year that followed, two things happened. One was the Freedom Riders hit Mississippi, and the other was that they moved Father LeBeau out of harm's way down to the Gulf Coast. So when I got back, Amzie said, well, we have to wait. But in the meantime, he got a letter from C.C. Bryant, who was the head of the NACP in Macomb. And C.C. told him, that's okay, that's my wife. She's just a little side there. So anyway, C.C. wrote Amzie and said he had read in Jet magazine that SNCC was going to start a voter registration program in the Delta. And so he wrote Amzie to send him some of his voter registration workers. So Amzie put me on a bus and I went down. And so that's how I ended up down in Southwest Mississippi. That's how we ended up recruiting John Hardy to come and work in Walpole County. Right. By the next year, we were back up in the Delta. And by the beginning of 1963, we had pretty well established a beachhead all across the Delta. And we were working with money from the Voter Education Project. So I said earlier that I experienced the civil rights movement as a coalition of the bottom and the top. So one of the other elements that emerged at the top was the Taconic Foundation. President Kennedy had Stephen Currier set up a foundation specifically to funnel money for voter registration into the South. And Currier had married a Mellon, so it was Mellon money. And Currier at that point had kind of brought together all the different foundations in and around this area of working on civil rights and those issues. And SNCC had, in the meantime, they wouldn't give money, the Voter Education Project wouldn't give money directly to SNCC. But we had set up in Mississippi an umbrella organization called the Council of Federated Organizations. Member Medgar Evers was the field secretary in Mississippi for the NAACP. Aaron Henry wore a lot of different hats. He was the head of the NAACP state branch, but he was also King's representative in Mississippi, so he signed on for King. And then Dave Dennis, who had taken over the work of CORE in Mississippi, signed on for CORE. So we got money from the Voter Education Project for under the COFO umbrella. So we had a meeting, this is in the early winter of '63. Randolph Blackwell came over from Atlanta. And we were driving him back to Greenville from Greenwood on Highway 82, and we were grease-gunned. Jimmy Travis was driving, I was sitting in the middle, and Randolph, three of us up front. So a grease gun is kind of like a machine gun. You know, it kind of tattooed the side of the car, blew all the windows away. Jimmy caught a bullet and slumped. I had to grab the wheels. We got off the road into brake. And after that, we decided we would converge on Greenwood, all the SNCC workers in Mississippi. And it happened at that time that the county, LaFleur County, had decided to cut off the commodities, the federal commodities. And so we raised money. Dick Gregory flew plane loads of food from Chicago. So we told people, well, look, the reason you don't have this food is because of the politics, so to get some of the food, you have to go down to register. So we got hundreds of people to go down to register, and SNCC got arrested, and we ended up in the federal district court. Burke had our cases removed from the state or the local court to the federal district court. And so I was on the witness stand in Greenville, Mississippi in the spring of 1963. Kennedy is still president, Bobby Kennedy, Attorney General, Burke Marshall, and then he sent John Doerr to be my lawyer. So the federal district judge, Clayton, just had one question for me. Why is SNCC taking illiterates down to register to vote? So sharecropper illiteracy was the subtext of the right to vote. And sharecropper illiteracy is kind of, depends on the idea of sharecropper education, an idea which is alive and well in our country. The idea that you are pre-assigned work, and so you get the education for which you have been pre-assigned. Right? So that's the second issue that I want us to think about. The first is the issue of the right to vote, and basically what I think about that is the country needs a constitutional, an affirmative constitutional right to vote, right? What we have now is a negative right to vote. And I also think what the country needs is to elevate public school education to the level of the Constitution of the country. So I want to read you, around that issue, an abstract written by Goodwin Liu that appeared in the Yale Law Journal It appeared in November 2006. We held our first meeting, Danny Glover, the Algebra Project, and about 150 people gathered at Howard University in the spring of 2004, announcing that we need a constitutional right to a quality public school education, and trying to begin a conversation in the country about that. Goodwin Liu, who wrote this article, spoke at that meeting. He's now on the Supreme Court in California. Obama did try to nominate him for an appeals court. It couldn't get out of the Senate committee because he's Supreme Court material, right? And so they were not going to let his nomination go through. But Jerry Brown then nominated him and put him on the Supreme Court in California. So a couple of years after we held our first meeting, Liu wrote this. I'm going to read the abstract to the article. For disadvantaged children in substandard schools, the recent success of educational adequacy lawsuits in state courts is a welcome development, and I'll talk about those. But the potential of this legal strategy to advance a national goal of equal educational opportunity is limited by a sobering and largely neglected fact. The most significant component of educational inequality across the nation is not within states, but between states. Despite the persistence of this inequality and its disparate impact on poor and minority students, the problem draws little policy attention and has evaded our constitutional radar. This article argues that the 14th Amendment authorizes and obligates Congress to ensure a meaningful floor of educational opportunity throughout the nation. The argument focuses on the amendment's opening words, the guarantee of national citizenship. This guarantee does more than designate a legal status. Together with Section 5, it obligates the national government to secure the full membership, effective participation, and equal dignity of all citizens in the national community. Through a novel historical account of major proposals for federal education aid between 1870 and 1890, I show that constitutional interpreters outside of the courts understood the Citizenship Clause to be a font of substantive guarantees that Congress has the power and duty to enforce. This history of legislative constitutionalism provides a robust instantiation of the social citizenship tradition in our constitutional heritage. It also leaves a rich legacy that informs the contemporary unmet duty of Congress to ensure educational adequacy for equal citizenship. So in 1968, 400 Mexican Americans walked out of their high school in San Antonio and marched on the San Antonio School District, demanding better schools and better teachers. And their mothers took it to the courts, and it eventually landed in the Supreme Court in 1971. Justice Powell was the Chief Justice. And what he said is the opposite of what Liu just said here. What he said in that opinion is there is no substantive constitutional right to an education, and so you have no right to come into the federal courts to seek relief, right? And so what happened after that is what Liu is talking about here, education adequacy lawsuits. So there are 45 suits and 45 cases around the country around equity issues. And what Lou is arguing here is that if we're thinking about a national solution to our education problems, it's not going to happen state by state, right? So Lou is arguing that there already is in the Constitution, not in the Equal Protection Clause, but in the Citizenship Clause, the opening statement, what it means. Because after all, the 14th Amendment said who the citizens were, right, for the first time, right, clearly, right, who are the citizens of this country. And what Lou is saying, that was not just a pro forma exercise, that it was substantive. The idea was that national citizenship was actually to mean something. And certainly if you think about a freedom rider crossing Alabama, that freedom rider is thinking, I'm a citizen of this country and it means something, right? If you think about the sharecroppers trying to register to vote in Mississippi, they are thinking the same thing. If you think about Fannie Lou Hamer and the Mississippi Freedom Democrats at the National Convention, they are thinking, I'm a citizen of the country and I have the right and the duty to participate in the national political scene, right? So for people, and if you ask anybody, do you have a right to an education, they will tell you yes, right? And so they think that they have a constitutional right. So one question for our country is, are we mature enough as a country to actually have a conversation about a constitutional right to an education? As you know, when I think about the civil rights movement, we got Jim Crow out of three distinct areas of American life: out of public accommodations, out of access to the vote, and then out of the National Democratic Party structure. But we did not get it out of education. So the Algebra Project thinks of that as part of our unfinished business from the 1960s, the issue of education. We got an introduction to the rich history here. I mean, it's really an honor to be talking in this hallowed ground here. Heather Williams has written a book called Self-Taught. And in the book, she talks about what was going on in South Carolina in the early 1800s, right? So South Carolina had passed a law in 1740, prohibited teaching slaves. But black people in South Carolina, she says, had devised means to circumvent the law. And in 1800, the legislature explicitly acknowledged that earlier laws had been insufficient to keep blacks in due subordination. Teaching had moved further underground. The legislature hoped to root it out by enacting statute that declared any assembly of slaves, free Negroes, mulattoes, and mestizos among themselves or with whites for the purpose of mental instruction, an unlawful meeting. The new law broadened both the scope of prohibited activity and the categories of individuals covered. Rather than merely criminalizing the teaching of writing, the 1800 statute outlawed mental instruction, which could include reading, writing, memorization, arithmetic, and much more. Furthermore, while the 1740 statute had only prohibited teaching slaves, the 1800 law prohibited teaching slaves and free blacks. Finally, the 1800 law aimed specifically to prevent African Americans from gathering in secret places to learn either before the rising of the sun or after the going down of the same. The legislature had undoubtedly become aware of clandestine schools meeting before dawn and late into the night. Lawmakers required magistrates to enter into such places to break down doors and to disperse such unlawful assemblies. The law subjected each person of color in the group to corporal punishment not to exceed 20 lashes. So I think the country has an unannounceable education policy, which is that we run failing schools and we rescue different categories of students. So all of our programs, vouchers, ABC programs, magnet schools, charter schools, affirmative action, you name it, all of these programs rescue different categories of students from our failing schools. We have no policy to actually fix our schools, right? I was at a meeting at ETS over a year ago. ETS had brought together the Urban League from around the country, and they had the directors of the two consortiums that are doing Common Core, Smarter Balanced and PARC, and they were there to explain to Urban League what was going on and what to expect. But they opened the meeting with a talk by the president of the College Board. And I was astounded because he said, not in these words, but in so many words, teachers are off the table. The country has no policy for providing the teachers that are needed to actually implement the Common Core. There is no policy. There is no policy. There is no policy to provide the teachers that are actually needed to implement the Common Core. And what was more surprising was that nobody blinked. Nobody raised, what does this mean for the kids who are in the school, right? And if you read the papers, you saw today that the state of Georgia put in jail 11 teachers and school people, right, on RICO, right? They charged them with racketeering for working with changing answers on these tests, right? And you read the papers, and what you're hearing in the papers is that they deprive these kids of their education, as though the state of Georgia and the country ever intended to educate them, right? I mean, we're dealing here with sharecropper education. We're dealing with an education system where you have a pre-assigned status in the country, and therefore you get the education for the status to which you have pre-assigned. Now, the only person that I know of who said that in print is James Bryan Conant. So Conant was president of Harvard from 1933 to 1953. And Conant got to be president of Harvard because the country went through what the sharecroppers call the panic crash, right? The Great Depression, right, 1929. And the country lost confidence in various segments of its leadership, and the Board of Trustees of Harvard decided they had to change the nature of the presidency at Harvard. And so Conant, a chemistry teacher, not from the educational elite class, but not from the economic elite class. He went to Roxbury Latin, right here, close by, right? The oldest private school in the country, right? Up here in Roxbury, right? Conant graduated from there. He took a look around and decided he wanted to change the nature and complexion of students at Harvard. he wanted public school students to be able to go to Harvard. This is 1933. And so to get into Harvard at that time, the tests were based on the private school curriculum. They had worked out a deal with the Ivy Leagues and the private school, Exeter, Andover, so forth, Groton. So he needed a way to be able to see who was worthy in the public schools of a Harvard education. And so got his dean, Henry Chauncey, to look for a test, and we had begun tests with World War I, right? We had begun mass testing in World War I, and then the people who did that went to Princeton and began working on those tests. And so there were tests available, the early versions of the SAT. And so the first class of Harvard National Scholars from public schools went to Harvard in 1934, and then all the Ivy Leagues began to use the SAT for their scholarship students from public schools. We're not talking black, right? We're talking white public schools from the Midwest, right? Getting into Harvard. Right? So World War II came and went, and Conant established ETS, the Educational Testing Service. He became its first chair of the board, and his dean, Henry Chauncey, became its first president. But then Conant, after the war, they sent him to Germany, where we were doing, remember, rebuilding Germany after World War II. Then he came back and took a look at public schools in this country and wrote a book. It's called Slums and Suburbs. And in it, he had this to say: as I read the history of the United States, this republic was born with a congenital defect, Negro slavery. Or, if one prefers another metaphor, we started life under a curse from which we are not yet free. After the victory of the North, the people of the United States, through their duly elected representatives in Congress, acquiesced for generations in the establishment of a tight caste system as a substitute for Negro slavery. As we now recognize so plainly, but so belatedly, a caste system finds its clearest manifestation in an educational system. So we have been running an educational system to drive a caste system, right? And we are silent. Right? So in 1749, a young black 9-year-old made the trip from West Africa and survived. And a young 24-year-old entrepreneur bought him. Charles Stewart bought Somerset to be his personal slave. The lives of Somerset and Stewart would not now be remembered except for an act of courage and tact by Stewart in 1762 during the French and Indian War. A ship carrying Spanish soldiers who had surrendered to the British and were being repatriated floundered off the coast near Norfolk, Virginia. The ship was under repair when a mob of Virginians attacked the soldiers, killing 2 and wounding several. Stewart intervened, quieted the mob, and saved the remaining Spaniards. Britain was grateful for his intervention and rewarded him with a position of authority over customs collectors from Quebec to Virginia. Somerset traveled with Stuart as he enforced the custom laws and met Stuart's friends and associates. So 20 years pass. Stuart is traveling with Somerset up and down the coast, right? He's in charge of all the customs, all the ports coming in. And then Stuart's sister takes sick, and he travels with Somerset to England to help take care of her children. So Somerset now in England sees his chance, because England is awash with Africans from all over, right? And going on the streets for Stuart, he makes a plan. He gets English godmother, bides his time, and then runs away. Stuart sends slave catchers after him. They grab him and put him on a ship bound for Jamaica. But Somerset's godmother hears about it and goes to the King's Bench, the highest and oldest court in England, and asks for a writ of habeas corpus. And Lord Mansfield, who is the chief judge of the King's Bench, sets him free. He orders the Captain Knowles, who was on the Anne and Mary, to come bring Somerset to court under habeas corpus, and sets him free and suggests that they not try to take this to trial. But the planters in England want a case because they want support for the commodities market, and they're afraid that if Somerset gets set free, then this will really endanger that market. So they have the trial. It happens in 1772. Lord Mansfield, bewigged, mounted the bench while the clerk called the case of James Somerset, a Negro on habeas corpus. Mansfield recited the facts, discussed the law briefly, and then made this statement. The state of slavery is of such a nature that it is incapable of being introduced on any reasons, moral or political, but only by positive law, i.e. by constitutional law, which preserves its force long after the reasons, occasion, and time itself from whence it was created is erased from memory. It's so odious that nothing can be suffered to support it but positive law. Whatever inconveniences, therefore, may follow from the decision, I cannot say this case is allowed or approved by the law of England, and therefore the black must be discharged. So on the eve of the American Revolution, colonialists in America got the message that slavery was not permissible. And slaves got the message, so they appeared advertisements, right? You can read them, right? This slave might be bound for England because he has heard about the Somerset case, right? So the preamble to the Constitution outlines the idea of a constitutional person, right? And of course, the preamble, the we the people, the reach of the we the people of the preamble were white men property owners, right? So we started out our country with a class of people who are the constitutional people in the country who are white men property owners. But we also started out our country with a class of people who are also people who have constitutional status, That's in Article 4, Section 3, Section 2, Paragraph 3. Those people are constitutional property. So we had these two ideas that we started out with, that we should have constitutional people, and we should also have constitutional property. The Somerset Clause, Article 4, Section 2, Paragraph 3. No person held to service or labor in one state under the laws thereof escaping into another shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor is due. So mind you, what we're dealing here is not states' rights, it's property rights, right? So we go for a whole 3/4 of a century, from 1787 right down to the War of the Constitutional People about their constitutional property, in which the major issue is the right of a constitutional person to reclaim his property over and against any state right. So the federal government is asked to intervene on behalf of property, right, owned by constitutional people, and fetch it whether the state wants to give it up or not. So states' rights were not an issue in our first constitutional era around this crucial part of our culture, dealing with who are the constitutional people in our country and what are their rights. Right? Circular 3591. Anybody? Circular 3591. So you can Google it. All you have to do is Google Circular 3591. So what turns up is a memorandum written by Attorney General Francis Biddle, Roosevelt's Attorney General, written on December 12, 1941. And he instructs every state attorney general that they should stop prosecuting peonage as debt, and they should prosecute it as involuntary servitude and slavery. Now, why is he doing that on December 12, 1941? Well, because of December 7th, 1941. And Roosevelt has decided that the country needs black men, and that Japan is going to propagandize black soldiers and ask them, why are you over here fighting us? And so they bring to an official end the practice after, in the second congressional era, right, of rounding up young black men by the tens and tens of thousands for vagrancy. You're walking the railroads, right? You have no money. You're arrested for having no money, and then you're fined and can't pay it, and you're turned over to the mines, right? Tennessee Coal and Iron, a subsidiary of U.S. Steel in Birmingham. You know, during the Civil War, it was a Confederate ship that could not be penetrated by, you know, the bombs and so forth, because of the iron and steel that was being made in the South. And so after the Civil War, this country industrialized on the backs of the iron and steel coming out of those mines, and then the cotton production on the plantations. So I think of Circular 3591 as a kind of a marker of the beginning of the end of the second congressional era, right? And you have to think that the civil rights movement that we had, the backdrop to it was the world wars. World War I, World War II, colonial people all across the planet in response to these wars and the turning up that happens with these wars, demanding their political voice, right? And so after World War II, we get the United Nations, right? I mean, the SNCC people at Howard were sitting in, I think it's Route 41, because you got African who are in the United Nations, they got their embassies in Washington, they have to travel back and forth from New York to Washington, they can't get anything to eat, right? So that movement of colonial peoples for a political voice, we are an internal colony in this country, right? And so the civil rights movement is a movement for, in line with what's going on around the planet, to get a political voice, right? And like the rest of the planet, we didn't get an economic voice, right? So I just came back from Atlanta. The Algebra Project has entered into a contract with the Atlanta Public Schools. And this is our third week beginning to work and talk with school people there. What we want and what we need in the country is a conversation about the bottom quartile. So we're in Atlanta under a contract to work with the bottom quartile in certain middle schools in Atlanta. So we have a metaphor in the country about an achievement gap. I think it's a worthless metaphor. And part of the reason it's worthless is that the gap that you want to close, when you get there, it doesn't get you anything. Even if you close it, because the dirty secret in the country is that 70% of the kids who graduate, having met that gap, remediate when they get to college, right? All these open enrollment colleges, they are remediating math, right? So the Algebra Project has set a standard. We're trying to get a different metaphor out there, the idea of some kind of platform or standard, as opposed to closing a gap, right? And that the only appropriate standard for the 21st century is that the kids graduate high school on time, ready to do college math for college credit, right? So we've been trying to get a conversation going about that, right? And we've worked really hard at the issue of, well, what does it take to get the students as they enter high school and who have experienced failure in the school system to begin to believe that they can do the math, and what kind of expectations do they have to set for themselves, and also what are the structured opportunities that have to be put in place so that they can do it. You know, we got No Child Left Behind as an accountability structure, but we got it as an accountability structure without an opportunity structure. So part of what we've been doing is really investigating what structures, what opportunity structures have to be put in place so that this is something that's actually we can think about doing, right? So I want to leave it at that, I think, in terms of this talk. So on the voting side and on the education side, we need to actually lift these up to the level of the Constitution, where we have in the Constitution an affirmative right to vote and a constitutional right to a quality public school education. And I'm finished for right now. You're all standing up, I can sit down. Please. Thank you. Please.
On this whole STEM education piece, could you give us an overview of, number one, why it's important and the direction that the community of color needs to take to embrace the need for that in today's digital era?
Right. So I think one way to think about it is that we're in the midst of an enormous technological shift, right? From industrial technology to information age technology. So if you think about industrial technology and what the literacies were and are, they were primarily reading and writing literacies. So the sharecroppers that were literate were the serfs of the industrial age, right? And industrial technology mechanized physical work. Information age technology does not do that. It organizes what we think about, right? And brings with it the issue of knowledge work, right? So right away, all the schools we have are artifacts of that earlier age, and we don't have a clue really. What are the schools that 100 years from now or 200 years from now, they will say, well, those are artifacts of the information age. We don't know, right, what the schools of the information age will actually be, right? We are working in the artifacts of the previous age, right? But the other thing to really be very clear about is that information age technology brings quantitative literacy on the table as important as reading and writing literacies, and we are not going to get away from it, right? So you can think that in the 20th century when, you know, I was in grade school, it was post office arithmetic was what was needed for everyone who graduated, right? You got to be able to function at the post office, right? So in this age, right, it's the tool that's organizing the work, right? So the tool that's organizing the computers, right, the software and so forth, it's a little logic, a little set theory, a little algebra, right? And so this is, you know, from the point of view of mathematics, a small shift. From the point of view of math literacy, as we are watching as it unfolds in our country, it's an enormous shift, right? And partly it's so enormous because we never decided that we had a responsibility for all the children, right? I mean, the country has forever had a problem with the two-letter word we, right?
I was watching a documentary, I think it was on PBS, and I have like several questions, just short. I don't know, have you heard of this song? Because I was just thinking about it. Hallelujah, I'm traveling. Hallelujah, ain't it fine? Hallelujah, I'm traveling down Freedom's main line. Okay, And second, do you have advice for my son? He couldn't make it today. He just turned 6. You know.
Does he know the song? Yeah, are you teaching him the song?
No, he knows other songs like, you know, read your Bible, pray every day. He will grow up, stuff like that.
So it sounds like you need to teach him that song.
And any other advice?
So where are you going to put your son in school?
Well, we're in Taunton, so that's like Bridgewater, Rockland, Taunton.
Okay.
So we're down there, so he's in Taunton schools right now.
He's in the public schools
Yeah.
there? Right. Have you gone in to check it out?
Yes, I have.
How do you do that?
Well, like, you know, first day I called and then they invited me, you know. and
Did
then-
you actually go into the classroom?
Yes, I did.
What did he feel? What did he say? Your son?
He likes it
He
there.
likes it? Does he like you in the classroom with him?
No.
No? Did you talk to him about that? That you need to periodically be in his classroom?
You know, I have.
I think that would really be important. I mean, you know, my wife who's getting up now. Okay. So Janet and I, it's my wife, we wanted our kids in the public school, but we wanted the school to work for them. Right? And so eventually that meant that, you know, I went into school as a parent. So the public schools are such now that you really have to keep if you want it to work for your son, then you have to get in there and make sure it's working for him.
Thank you.
I don't know if that's advice to your son or to you.
Thanking Bob Moses.
Thank you. Thank you.
And the reality is, it's dangerous anyway. People are like, are you afraid to die? I'm afraid to live in this world. So like, so what, right? Like, I'm afraid to walk down the street in an America where the police watch the blood drain out of a 12-year-old and he dies 16 hours later. That scares me. That scares me more than the shooter does.